Fight, 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 fight.
Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. Hi. 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 How are you guys doing? How are you guys doing? Let me open up with breaking the first rule of the internet and apologizing for yesterday. I really wanted to do a stream yesterday, but I didn't get home till after midnight. So that was just not on the table. Sometimes shit goes south and, well, unfortunately, shit went south and I wasn't home. But I am here tonight, so we are back. Believe it or not, I really do want to do 5 streams in a fucking week. And this week I'm feeling juiced up and energized, and it would be perfect week for it. And I fucked it up on a Tuesday. So sorry, but am looking to do some stuff, hopefully, at least on locals in the middle of the day, someday this week, which they're running out. So we'll figure that out. But thanks for hanging with me. I tried to update on locals as soon as I knew I would not be not be home. But alas, you know, that's the way it fucking goes. With that said, tonight we got a whole shite-load of topics. A shite-load of topics. We've got pistol braces. We've got an idiot Minnesota senator talking about Roe versus Wade. And it's got some important stuff to it. We've got trans agenda teachers. We've got a CNN producer who just got sentenced for Pride Month. Just kidding. Doesn't technically have anything to do with Pride Month, I don't think, but it has a whole lot to do with him being a fucking pedophile. So we're going to talk about that. It's going to go gross, but that's what we've got to do, is talk about this shit. And I do not think it's an accident that we keep seeing this stuff creep out of media, mainstream media outlets. But we'll get there. We will get there. So what we're going to do with the pistol braces is kind of where we're going to open the show tonight. Kind of a heavy legal sort of look into their final reply brief. This is the Firearms Policy Coalition suing Gork? Whatever. Firearms Policy Coalition's brief in the appeal on the pistol braces ruling. The pistol brace ruling was, of course, the finding that, or not the ruling, I should say, the rule. The rule established that pistol braces are machine guns regulated by, well, not really machine guns. They turn a pistol into a short-barreled rifle according to the rule, which makes them a short-barreled rifle in and of themselves, which makes them a restricted weapon under the National Firearms Act, which means that you need a special tax stamp and registration and fingerprinting and all the bullshit that comes with that. Which puts an extra burden on gun owners. It also literally requires you to be put on a government list to exercise your Second Amendment rights. I don't know about you, but I think government lists are bullshit. And anyone who supports government lists, except for things like pedophiles, should probably be punched right in their, their dick, if they have one. It's 2023. I don't know. But yeah, and yes, there are other items that are similarly classified that are in no way machine guns. They're in no way short barrel rifles, short barrel shotguns, but they get the same classification. One of the big ones is suppressors. Suppressors obviously being something that is so propagandized by their cool use and name of silencers in movies, even though that is not at all practical for what they do. But politicians are fucking stupid. So they went ahead and treated them as if they're a machine gun or some other similar item, like a hand grenade, an explosive shell from a howitzer. All of these things are ridiculous. But we're going to be talking about that, and we'll do it in the context of their brief. Now, their brief is 39 pages, and it's the reply brief, so it's the last one. I don't know that we're going to go through 39 pages. A lot of times on these briefs, you can get the gist of the legal arguments and the main points from the opening section, which is usually, 1 to, maybe 7 to 10 pages tops. And we'll be able to extract from there the basic scope of main arguments, but maybe we'll go farther. I actually haven't read it yet, because I like to read these things with you guys and give on the go sort of reactions and legal kind of thoughts as we go. That, and it also came out, I think, today, and I haven't had time to read it. If it came out yesterday, I didn't see it. I think it was published yesterday on their website. I didn't see it till today, and I haven't had time to read the whole thing, but we're going to take a peek at it. If it merits a longer, more dedicated show to it, happy to do that. But I tend to only, here's the skinny. I know how I opened my channel was reading full legal documents, and that kind of carried through the Vic Mignogna lawsuit and some other lawsuits at times. But I've made a decision along the way that gets really, really tedious unless I, and by extension, the channel's focus, is really invested in that particular lawsuit on a level that merits doing full shows that will keep people's interest through really dry legal documents, or if the legal documents are exceedingly, entertaining, funny, unique, something like that. But going through 39 pages of legal document gets boring. It gets trying for me. And if I'm not into it, it's going to be hard for me to sell the show on that. But if it merits further reading, maybe we can go and read them in other documents. But I'm trying to limit that to specific cases that we're following more closely, which I have not done in a while, but that's on the menu as we find some. Finding interesting cases worthy of reading full documents, though, is not the easiest thing in the world, because most of them are written by competent lawyers on both sides, and they're pretty dry. Talked about this before, but just kind of to explain why we're going to take a peek at it, and we can explore further if needed, which is the same thing you do well, never mind. I won't get into that. That's a joke. That's a joke we're not going to tell. The other thing to talk about right now is I have been kind of talking about this a little bit again, and I feel like I'm talking about it all the time, and some of you probably do too, but not everybody catches every show or every part of every show. So I'm going to reiterate it a couple more times, but there is a full video that I'm writing. I write up here and then put it down on paper, but I'm writing a video out, which I don't do very often, to kind of talk about the direction of the channel, where things have been and where they've been, where I want them to be. And I'm trying to be very candid about this because I have not been happy with how I've done the show over the past couple months specifically, but really over the last 6 months. I was trying to steer the show in certain directions, and despite my efforts to do so, I found myself lazily steering it in different directions that were really easy. It has to do with a whole bunch of different factors, a lot of it being stress and dealing with some depression type stuff. These aren't excuses. They're just explanations. I'm not whining, not bitching about it, just telling you kind of what's going on. And again, attempting to be honest about it. There's a whole video coming out about it, but I have different plans for how the show is going to be directed going forward. Again, much more intentional sort of things. And I do this from time to time, but it's a pulse check on me, the show, the audience, my personal mental health, and all of that shit. And I try and do everything up front and out in the open for a couple reasons. One, because I think it's respectful to you guys. You guys come and watch the show. Some of you super chat, some of you participate, some of you join in locals. Anybody here, I'm so fucking grateful every day that people show up. It's No matter how many times I do it, every day it's a surprise, and that's awesome. But I feel like I owe that to the audience to be as transparent as possible about things. Sometimes people don't like it, but with that, though, I also want it to be a note for so many other people who either are streamers or content creators, or who are thinking about doing it or know someone who is, so that they have a reference for what other people go through. In a lot of industries, including this one, people tend to be pretty tight-lipped about their own issues, about their maybe their mental health or stress or their personal lives and how they're impacted by what they do, because, well, you really don't want people digging through your fucking life all the time. They do. There are very insane people out there who want to dig into everything you do, everything you say, and not in a positive way because they like you. So a lot of people shy away from it. I want to make sure there are other people who can see that, you know, what people go through in this sort of profession, so that they can identify that shit and hopefully work on it on themselves and learn from the mistakes or wisdom or bad experiences or good experiences of someone else. So I try to keep everything I can as open as possible on that. And so there's a bunch of, they're not big changes, like, really. It's just an intentional sort of direction of shows. I've been trying to emulate and model that ahead of time. Last week is a good example of kind of what I want to be doing. The new show that I did with Ed Greenwood is another great example of kind of steering things in a particular direction. And I hope to keep doing that as we go, rather than just talking about it. But I just wanted you guys to know there is a video that I'm working on, trying to get that done pretty soon, because I don't want it to go stale in my brain. With that, I do want to explain one more thing. I talked about this on Camelot show earlier tonight. The Fun Friday things should be coming back pretty soon. However, the idea is to have them fun, not disgusting. And a very lazy, easy thing for me to do personally is to let humor go into very crude and gross places. And I know that that's what was going on some of the Friday shows, and that kind of manifested in the past couple of them. And that was not intentional. That was lazy. And because of that, and not really wanting to like put that out there, and I know it turned off a bunch of people. Some people really like it, and that's cool. I kind of do too, which is why it's lazy for me. It's really easy for me to get into dirty fucking humor, but it's also not that great for everybody out there. It's very niche taste. And so Fun Fridays are supposed to be fun. And what they were getting into was like very, very drunken, kind of nasty conversation that, look, I'm all for crudeness and irreverence, but there is a limit of where it should go. So kind of reeling that in a little bit and making sure it is an actual fun show with some topics that aren't always the same thing every single week. It should not be the same thing. And for anyone who thinks that lies on anyone's shoulders but mine, of course not. It's all on my shoulders and how I direct the show. But also, before anybody thinks otherwise, Camelot will, of course, be a returning guest on Fridays. He's my boy. We love hanging out. And we also don't have to talk about degenerate shit. It's just at the end of the week, that was an easy thing for me to do without having to put in too much like prep work or thought into doing a show. And that's half what I wanted on Friday, was like a little bit of not really prep needed, bring people on and have some interactions, direct the show, but it kept going to the same place. And that's not the goal of it, right? Fridays should be fun, entertaining, and different from week to week, and they weren't. So we're going to work on that, fix that. But that involves me getting myself into the right headspace and cutting back on some liquor. We're not going teetotaler here. I love whiskey, and it's fine. But there are, the way I said it on Locals last night was something that was a quirk of the show, which was drinking lawyer, became a feature of the show, which was there's always liquor, which then became kind of a crutch. And I think also detrimental to the show, which is drunken lawyer, like way too drunk lawyer. And I, watched back some of the stuff that I'd put out, and it's like, dude, you can't drink 9 fucking shots on a show and expect to have anything other than just retardedness come out. So that's kind of some directional changes. If you want a little bit more of an explanation, watch my local stream from last night. No, 2 nights ago. And there's a little more in there, but again, a more full explanation is coming. I know some people have been kind of very cautiously offering polite criticisms of the Friday show and some other stuff. And like, I gotta let you guys know, I do read those and try and internalize them. But as I said the other night, if you're not in the place of being self-critical, outside critique is never going to work. And people like can yell at you and do whatever, but you have to make decisions in your own life on how you address stuff. No offense, I love you guys, but there's nothing that you guys can do that give you permission to speak into how I do things. And like, it doesn't matter if it's constructive criticism or not. Like it's mostly going to be looked at. And then unless I'm in a place of like self-criticalness or introspection, it's going to be ignored, because you can't let other people direct how you do something, especially in entertainment. But you can take constructive advice when you realize on your own, or on your own timeline, I should say, that you need to be doing that. So that's what's going on. Don't, I just, again, I'm trying to be open about everything, and keep people informed with that. So that's what's on the menu. We will have, assuming nothing weird happens, show tomorrow, show Friday as well. And hopefully I'll have some stuff announced for that. As for the direct examination show, I do have some really great guests in mind for that. People who have never been on this channel before, who I want to introduce you guys to, introduce myself to. And I think we're going to do great things on that. What else? What's up with the Drex stream? Next time I see Drex, he'll be on the show. I haven't seen him for quite a while. Our schedules sometimes just get way out of sync. When we hang out more, our cycles sync up, and then we can do more shows together. But sometimes they're just way out of sync. He's traveling. I'm traveling. His work schedule. I have a stream. This is my work schedule, but his work schedule doesn't always allow him to come out and hang out with us. So kind of just depends. But, Drex is my homie from forever. And so love having him on the shows whenever he's available. What's Drex's job? The man has not talked about his job online. I'm not going to talk about his job online because, like I said, some people are fucking insane and want to peer into and interfere in every single piece of your life. And that is the nasty side of the internet that will never go away. You can't fix it. You can't change it. You can't stop it. You've got to just go ahead and acknowledge that it's there and deal with it. That's just how it will be. But yeah. Sounds good. Jay is bored. Sounds good. But all right. So where are we? Oh, the pistol brace. The pistol brace thing. Here we go. Let me find it. And no, I can say that Drexel is not a pimp. People get again tripped up over stories from his past and think that that's like a thing that he does. I mean, I'm not going to say he doesn't, have his own sexual issues or whatever, but the idea that he's like doing that as a profession is it's always funny to me. But no, he has a regular job, like a real people job, not a fake internet people job. So, so here we go. What, oh, we got a super chat here. The Coco Nino. Oh shit. Had to say goodbye to the second of my famous puppies yesterday. Google BuzzFeed April showers. Vader, the black one, gave them hell. He rarely listened, loved to run away, barked at everyone, but was always gentle with my children and is a good boy. Oh, that sucks. Very, very sorry to hear that. I'm not the biggest fan of dogs in general, but mostly because I don't want to take care of them. It's not that I, don't like them or think other people shouldn't like them. I don't like taking care of. I already got 5 kids. I don't want to take care of dogs also. So with that, thank you, Coco Nino. Really appreciate that. Okay. What do we got? Why do I hate Ryan? Because he deserves it. Did I tweet about this today? I don't think I did. I think I fucking forgot to tweet this out. Yeah, that was dumb. Oh well. Too late now. I'm not going to do it now. That'd be a disaster. Okay. What do we got? Yes, firearms policy. So here's their announcement. Let's take a look at that, and then we'll dig into the brief. Where are we? All right, here we go. FPC completes appellate injunction briefing in lawsuit challenging ATF pistol brace rule. This is from the Firearms Policy Coalition. So this is written on their webpage. Today, Firearms Policy Coalition announced the filing of a reply brief with the Fifth Circuit Court of Appeals in Mock versus Garland. FPC and FPC Action Foundation's challenge to ATF's pistol brace rule. The brief was filed less than 1 month after the court clarified that its injunction against the rule covers FPC's members. The brief, which was the final filing in the case before oral argument, can be viewed at fpclegal.org, which we're going to check out in just a minute. Nothing in Appellee's rehashed arguments alters the conclusion already reached by the motions panel. Argues the brief. Appellants remain likely to win on the merits because a braced pistol is a constitutionally protected bearable arm, and the agencies have not met their burden of showing that the right to keep and bear arms historically allowed NFA-like regulation of braced pistols or short-barreled rifles, however defined. So this is going back very obviously to the massive decision in the most recent decision in the Second Amendment fight from the Supreme Court, which is Bruin. Bruin was penned by Clarence Thomas, and Clarence Thomas effectively said, I'm not going to have the exact quote off the top of my head here, but any infringement on the Second Amendment has to comport with the traditional infringements or regulations that were in existence at the time of the drafting of the Second Amendment, which is almost none. That leaves a lot of room for Second Amendment, not expansion, but return to what the Second Amendment was supposed to be. The amount of regulation that existed in 1791 when the Second Amendment was ratified is basically zero. They just didn't have any. You could own whatever weapon existed, whatever gun, whatever arm, whatever thing, from sword to knife to hammer to firearm to cannon to warship. The biggest weapons of war were privately owned at the time. And so any argument against that under the Second Amendment really doesn't make sense. Now, does that mean the Supreme Court is going to be like, yep, McNukes for everybody? No. But it means that they should. And I know that makes people very uncomfortable. I know that makes people very, very fucking uncomfortable. But if we're talking about the legal wording of the Second Amendment and how it's interpreted under Bruin, that's what it means. The right to not only have, but to bear arms, to bring something on your person, to bear it, to have it out in public, to have it out at your home, or really anywhere else exists. And the only way that right should be infringed is by your voluntary surrender of it, which usually means and manifests in our society as your commission of a crime that would merit the removal of said right. That's how we deal with the removal of rights or the infringement of rights most of the time. Now, there can be smaller infringements based on these constitutional tests that have been derived in other places, like the First Amendment has strict scrutiny. So if it's under strict scrutiny, it has to be a compelling government interest, and it has to be the least restrictive means of restricting the right, so you don't sweep up otherwise protected activity. which makes it really hard to do for free speech. So that's how they've done that in other places. Bruin is now the test is the one penned by Clarence Thomas, that it must comport with the traditional manners and mechanisms for restricting gun rights at the time of the adoption of the Second Amendment. It's a very constitutional, historical perspective for something called a judicial perspective. And that's a critical thing. We've never had a Second Amendment test because the Second Amendment just isn't challenged or tested in any way at the Supreme Court very often. And there's a couple reasons why, but the times that it's been most importantly challenged have been Miller, U.S. v. Miller, 1939. And then from 1939, there's really nothing major until 2008 when we get DC versus Heller. And then we get McDonald, I think, in 2010, which is kind of a mirror image of DC versus Heller, coming out of Chicago versus Washington, D.C. And then, of course, the next one is Bruin, which is 2021. So there's really four major Second Amendment cases. We don't get much testing of the Second Amendment. And prior to Miller, there's basically nothing. The reason that there's basically nothing challenging the Second Amendment is because the wording has always been clear and unambiguous. The right to keep and bear arms, the right of the people to keep and bear arms shall not be infringed. And it wasn't. It wasn't infringed. That's why there's no challenge to it until 1939, which follows the passage of the National Firearms Act, which sought to regulate, it sought to regulate pistols originally, but that kind of failed. And then they get into short barrel rifles. Fuddbusters is a little bit more knowledgeable and clear on the subject than I am. But long story short, what they ended up doing was regulating, they regulated short barrel rifles, short barreled shotguns, and other dangerous weapons, particularly dangerous weapons, which eventually, along with the Gun Control Act of 1968, led to the machine gun ban sometime in 1986. But there's kind of the progression. But up until the National Firearms Act, there weren't nationwide infringements on Second Amendment rights, on gun ownership at all. There may have been individual state infringements here and there. And that's because prior to Reconstruction, states were able to infringe on constitutional rights prior to the passage of the 14th Amendment. But once the 14th Amendment is passed, those state level infringements get the Bill of Rights applied to them through the 14th Amendment, and we kind of get away from that. But for well over 100 fucking years, our country recognized that Second Amendment rights were unambiguous. And now we have politicians trying to rewrite history. We have historians trying to rewrite history. We have media personalities trying to rewrite history and pretend that regulation of firearms is something that was always done. It was limited only to militias, not by people. That the idea, the founders would be shocked to have someone bring a gun or a rifle into a church or a courthouse or a grocery store or a market or whatever, or a school, heaven forbid. All of that is new. Every fucking bit of that is actually new. And generally, we're talking in the last 50 to 60 years. All of these things being extremely commonplace and even expected at the time of the passage of the Second Amendment. And yes, even in the big cities, even in the metro area, all of those places, guns would be not only not suspect, they would be expected and completely innocuous. And the idea that there are people now trying to tell us that this would be something that Americans would be conflicted over is silly. Very, very silly. But that being said, that just is kind of background on how important this Bruin decision ended up being. The Supreme Court really took a huge step on Bruin from a much smaller issue and laid out the groundwork for the Second Amendment and how it's interpreted going forward. Now, that being said, states are largely ignoring Bruin. Appellate courts are ignoring Bruin, and the Supreme Court is going to have to go ahead again and clarify Bruin and repeat the test, or they're going to scale it back. If you notice, like Clarence Thomas, Alito, and Gorsuch all get killed in random plane accidents or something, you know they're going to have a Second Amendment case coming. That's what you'll know. That'll be the telltale sign. Until then, we'll see how long the Supreme Court holds off on ruling again. I mean, the last time it was only 11 years between Second Amendment cases. But if they all get fucking killed and a bunch of liberals replace them on the bench during Joe Biden's insane senile presidency, then you'll know that we're going to see the Second Amendment get clarified and we'll see Bruin completely gutted. That's how that's going to go. And that's what they really want to do. Make no mistake. That's what they really want to do. And if they could just find a way to kill off those damn pesky conservative justices, that would be in the plan. And since they can't obviously kill them, I don't know if you guys have seen, but now after Clarence Thomas's ethics problems that they've been harping on for months and months and months, Justice Alito has an ethics problem brought up by ProPublica. The assault on the conservative ethics of conservative justices is nonstop. It is rampant. It is way overblown. And the entire idea is to hoodwink the public into thinking that there's an issue where there isn't. And when I say there isn't an issue on the ethics of the Supreme Court, it's not because there isn't an issue. It's because there isn't a legally recognized issue, and Congress and the presidency have no power to regulate how the Supreme Court operates outside of impeachment. But they know that impeaching a justice will look extremely political, and they don't want to do it. They're trying to build up a groundswell of political capital to do that. If they can build up enough political capital to burn a conservative justice on impeachment, then they might try that. For now, they're just going to rally up negative sentiment towards particularly conservatives on the court. They're going to largely leave the liberal justices alone in that front. And that's how they're going to sort of approach the inability to just fucking kill them. And that groundswell of political support has a couple different outcomes that are possible. One is impeachment. A lesser damaging outcome would be the decision that we need to balance the court with more justices. That's where Congress believes they can act. It's not actually necessary, but Congress could pass a law, could update the Judicial Act of 1802, which has been updated since then, to allow for more than 9 justices, which would then lead to the appointment of probably 3 or more liberal justices by whatever Democrat would be the president at the time of the passage of that bill. But they've got to build the political capital to do so, because right now it would look like a power grab. If they say we're going to rein in the ethics on the court, we're going to balance out the court because it's set up to be a conservative court forever, and that's not the will of the people. If they can do that by painting conservatives in a bad light, then they can use that political capital in multiple ways. And I would expect an attempt to change the court in some very significant way in the next decade. But these are long processes. But they play a long fucking game. This shit has been going since the 19 teens, the beginning of the progressive era, continued heavily through FDR, which is when he actually threatened to go ahead and add justices to pack the court to keep the New Deal. And what the justices did back then was they stopped striking down elements of the New Deal that FDR had brought in, and they started ruling in FDR's favor. They were so scared of the president's power to basically appoint justices into their own irrelevancy that they just complied. So I think we will see that happen. Not necessarily that, but some major attempt to shift the definition of the Supreme Court over the next decade. But we'll see how that goes. Kind of interesting to think about. We've got Just Joy. Can I get a toast to my hubby? First steps today after shattering his leg 2 months ago. And we became first-time grandparents 2 weeks ago to a beautiful baby girl. Good on you for unplugging for a few weeks. Family is everything that it is. Yes, I got a toast for you. What are we going to drink? I'll save that one. I haven't done a whiskey review show in a long time. So I do need to do a whiskey review show. That was something that I was supposed to do at least once a month. And I've been very, very lax on doing that. So I have some new whiskeys that I haven't opened yet. So we'll do that soon. All right. 2, Just Joy, and in particular, her husband, making the difficult first steps of rehabbing a nasty, nasty injury. But of course, blessings to them being bolstered by the birth of their first grandchild. May the child and the grandpa have wonderful paths to healthy futures and long lives together, learning just what it means to be in that special relationship. Cheers. All right. Okay, what do we got next? Back to this. Plaintiffs are requesting that the Fifth Circuit issue a preliminary injunction to preserve the status quo while they argue their full case, functionally extending the injunction beyond just the length of the appeal. The case is set for argument before the Fifth Circuit on June 29th. Firearms Policy Coalition and Firearms Policy Coalition AF, I don't know what the fuck that is, have specifically requested an injunction that will extend to all individuals, not just plaintiffs and their members and customers. Yes, this is the interesting facet of the injunction issued originally by the court, was that the injunction only applied narrowly to the plaintiffs and their members, not to anybody else. So everybody else still had to comply with the pistol brace classification. Quote, the public has no interest in the unlawful enforcement of ATF's rule and the irreparable harms that accompany it. This court should thus reverse the district court and enter a nationwide preliminary injunction to prevent these harms. All we're asking is for the Fifth Circuit to ensure that peaceable people across the United States are protected from ATF's enforcement of its unlawful and unconstitutional pistol brace rule for the length of the case, said Cody J. Wisniewski, FPCAF senior attorney for constitutional litigation, FPC's counsel in the case. The firearms at issue here have been properly treated as pistols for a decade. We simply want to preserve that status quo while we make our full case to the court. And of course, the harm is irreparable. I know some people would suggest that it's not like, well, it's just the registration of your thing and a $200 tax stamp. That's not like irreparable. But no, any infringements on your rights or any requirement to purchase your right from a government due to an unconstitutional rule is an infringement on the right that cannot be repaired. Even if the government refunds you your $200, you'll always be on the government list as having this thing. And one of the main features of having an unrestricted access to your Second Amendment rights is not having the government keep a list of your exercise of your rights. It would be insane if we allowed the government to have a list of every time someone, like every person who was not searched because the police like did something. It would be insane to allow the government to keep a list of everyone who spoke or went to church and what church they went to because they had to register their church application or anything like that. We do not allow government lists for most things because those lists lead to abuse. That's how it goes. And so we certainly don't want people having to sign up for a list, having to submit themselves to very extensive criminal background checks, having to submit fingerprints to the government for lawful activity, and then, of course, having to pay a tax on something that should not be taxed. Those are irreparable infringements on personal rights. Individuals who would like to join the Firearms Policy Coalition's grassroots army and support important pro-rights lawsuits and blah, 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 can do this here. I don't want to read the rest of that crap. Boring. Let me go to the, here's the reply brief. Let's see. Dismiss that. You go the fuck away. Go the fuck away. There we go. All right. So here we're going to get a summary of the case. Just a second. We got to get past all the introductory bullshit. I went too far. Here we go. Here we go. The introduction. The agencies assume that braced pistols are short-barreled rifles. Now, real quick, let me talk about this. This is this artifact of weird shit that is not actually within the Constitution, but has been allowed by the Supreme Court for a long time. It's called Chevron deference. And this is where the court relies on the expertise of a constitutionally sound, arguably, administrative body created by Congress under a law, in this case, the ATF. So the ATF is allowed to interpret Congress's laws in the way that they will, and the Supreme Court will generally defer to how that interpretation goes, recognizing the administrative agency as an expert on the subject. The obvious failing of Chevron deference is that government employees are fucking dumb. I don't know how else to say it. You might be a wonderful government employee, but the rest of your coworkers are fucking dumb and you know it. And so what they will do is they will interpret things in very stupid ways, usually intentionally. Here, the interpretation that a brace on a pistol is a short-barreled rifle under the law, excluding short-barreled rifles, is silly. It's a brace. It's a thing that you attach to a pistol. It doesn't magically transform the pistol into not a pistol. And more importantly, the ruling is that the brace itself is a short-barreled rifle. Not that the brace attached to a pistol is a short-barreled rifle. Not that it actually converts it while it's attached, but that the brace itself, this thing that straps around your wrist and hooks onto your fucking gun, is a short-barreled rifle by itself. Obviously a ludicrous assertion, because if you have a pistol brace, you cannot shoot a bullet out of it. So it can't be a rifle. But the law does not actually restrict things that make a pistol into a short-barreled rifle. The law only restricts short-barreled rifles. We saw the same thing with the bump stock ban. The bump stock is not a machine gun. The bump stock is not an automated weapon. It's actually also doesn't make an automatic weapon. It just facilitates faster trigger pulls in general. Faster trigger pulls are irrelevant to the fucking law. First of all, I will just go ahead and say that the machine gun restriction is unconstitutional on its face, but that hasn't been decided by the court. That's just my opinion, that it fully violates the Second Amendment. But that being said, even assuming that the machine gun restriction is a valid restriction under the Constitution, a bump stock is not a machine gun. It cannot be a machine gun, and Congress would have an opportunity to just write a law to make a bump stock a banned item under the National Firearms Act. Just amend the act. Why don't they do it? Well, that was fun. Why don't they do it? It would be politically difficult for them to do it. There would be heavy resistance from Republicans, Democrats in blue districts, in gun-friendly states and districts would have knock it the fuck off, would have a lot of trouble with their constituents having problems with this thing. It's unpopular. So instead, they rely on an administrative agency to make a rule change through the executive branch's sort of direction. And that is not how law should be done. Congress has the lawmaking power, and they don't get to pass the lawmaking power down to agencies. They're supposed to establish within the law very clear sort of directives on how the law should work. But again, SCOTUS dropped the ball years ago with Chevron, where they allowed these administrative agencies to make these sort of rules work and then defer to their expertise unless you overcome a huge burden in overturning that decision. So now we're stuck with this bullshit where a strap that attaches to a gun is somehow a gun in and of itself, and not only a gun, but an illegal one. It doesn't fit the description of a short-barreled rifle. It doesn't have the function of a short-barreled rifle, but it is one under the law. In the same way, a bump stock does not fit the description of a machine gun, nor does a bump stock make a gun a machine gun, nor does it do anything of the function, but it is a machine gun. And in the same way, suppressors are treated in the same way. But you know, that's a whole nother story. All right. So here we go. We are here. Yes. So they are subject to the National Firearms Act by ignoring the definition of a handgun throughout their 50 pages of briefing. But the statutory text could not be clearer. Quote, a handgun is a short-stocked firearm, quote, designed to be held and fired by the use of a single hand. That's actually codified in law, 18 U.S.C. section 921A30. A stabilizing brace designed to facilitate the single-handed firing of handguns is definitionally part of a weapon designed to be fired by one hand, and firearms with such braces are thus handguns of pistols and NFA handguns or pistols and NFA exempt. The agencies ignore this obvious textual conclusion by ambiguously expanding the definition of a rifle to intrude upon the definitions of a handgun whenever the agencies, applying indeterminate multi-factor discretion, see fit to criminalize any pistol that has or could be fitted with a stabilizing brace. But the agency's malleable "I know it when I see it" standard, brief for appellees 3 to 5, offers no certainty to law-abiding citizens and gives excessive discretion to the agencies to create crimes. These are references to constitutional concepts called overbreadth and vagueness. So it allows the agency to wrap up otherwise constitutionally protected activity in overbreadth, and then vagueness would be that a reasonable person reading the law cannot be sure on the application of the law to their activities. It's too vague. And that's because we're allowing the agencies to create rules as they see fit, which should not be the standard. But we let it happen. And we've been letting it happen forever. We've created a fourth branch of government, which is the administrative branch of government. And that administrative branch has an unconstitutional level of power, one, because it doesn't actually exist, and two, because the courts have allowed that rulemaking to proceed. All right, back to this. Whatever the faux aesthetic similarities between the agency's cherry-picked pictures of short barrel rifles with stocks and pistols with stabilizing braces, firearms with stocks are rifles designed and intended to be fired from the shoulder, while firearms with braces are handguns designed to be braced on the forearm and fired with one hand. That each could be used in a manner contrary to their design does not convert one into the other. Nothing in appellee's rehashed arguments alters the conclusion already reached by the motions panel. Appellants remain likely to win on the merits because a brace pistol is a constitutionally protected bearable arm, and the agencies have not met their burden of showing that the right to keep and bear arms historically allowed NFA-like regulation of brace pistols or SBRs, however defined. Appellants are also likely to show that the NFA does not authorize the final rule, and that if it does, the uncertainty of the final rule's requirement, not to mention the statute as interpreted by the agencies and the district court, triggers the rule of lenity or the void for vagueness doctrine. And the rule of lenity is something that Robert Barnes has described on this channel before, and probably on Viva's channel several times. But the rule of lenity is basically a rule within criminal law that means that a reasonably intelligent person of the general population can have an expectation that their activities violate a law if they would have been aware of the law. Ignorance that the law exists is not an excuse to violate it, but if a reasonable person reads the law, they should be able to reasonably understand what part of their activity would violate it. We talked about this in the context specifically of Kyle Rittenhouse and him having a firearm. The law was not actually written to punish a minor for having a firearm in Wisconsin. That was not the goal of the law. It's not easily read into the law. A reasonable person reading that law would not come to the conclusion that Kyle Rittenhouse merely having a firearm and carrying it in a legal manner in an open place that would be otherwise legal if he was just a year older would actually violate that law, because the law does not say that minors cannot carry a rifle. So that's where we've talked about the rule of lenity before, but the rule of lenity is a defense to what we would call an improper criminal prosecution. So keeping going, the remaining factors also favor a preliminary injunction. The final rule irreparably harms appellants by infringing on their right to keep and bear arms while threatening them with criminal sanctions if they fail to comply, either knowingly or inadvertently with the final rule's unlawful requirements. And it effectively destroys the market for braced pistols, making it likely that appellant Maxim Defense and businesses like it will suffer unrecoverable losses or go out of business entirely. Public has no interest in the unlawful enforcement of such a rule and the irreparable harms that accompany it. This court should thus reverse the district court and enter a nationwide preliminary injunction to prevent these harms. This is a good argument, good introduction. It hits the main points. It hits the constitutional issues, and it argues for an expansion of the injunction based on the requirements that there would be irreparable harm and there is no public interest in the injunction. Now, of course, the government, if it were allowed to reply here, would argue that lack of enforcement would lead to further criminal acts involving braced pistols, which is a ludicrous fucking assertion because we do not have a rash of braced pistol mass shootings going on in the United States. And this is another one of these weird attempts to regulate something that is not actually at issue for crime or the general public in regards to firearms, because they have trouble regulating the one most popular criminal act assisting item, which is the handgun. The overwhelming number of shootings in America occur with a handgun. Yet handguns are probably the most protected item, especially after DC versus Heller. But handguns have always been recognized as an effective tool, well, since they were invented, as an effective tool for self-defense of the home, of the person. They're small, they're not threatening, they can be easily concealed if that is the desire of a state. Handguns are kind of the de facto protected firearm in the United States. But again, they are the most commonly used murder weapon, the most commonly used assaultive firearm. They are the number one. They're also probably the most popularly owned classification of gun in the United States. The attacks on AR-15s, rifles, brace pistols, bump stocks, those are all not founded in a logical nexus of high criminal activity that is actually in the public interest to suppress. The intent of these things is to make busy looking political while restricting things that your opponents like and use. Again, putting more and more gun enthusiasts on lists, increasing public sentiment against them as somehow inherently criminal people or violative of peace, which is nonsense. But that's how they roll. That's how they do. They want to make their enemies look like bad guys, so they go ahead and attack scary things. They sensationalize them. Oh, man, this pistol brace increases the accuracy by X%. It makes a shooter into a deadly shooter. And imagine a mass shooter using a pistol brace to murder children. You can hear the rhetoric flowing out of some fucking idiot Democrat congressman's mouth about these things, completely uninformed on the issue, how they work, what they actually do, and ultimately the popularity of such things. That's by design. If they go straight for the throat, the person will raise their arm and guard it. But if they go for these fringe items, activities, accessories that are typically possessed only by enthusiasts that they can easily label as crazies, they actually will get not only sometimes deference, but they will get buy-in from organizations like the NRA. The NRA has not been supportive of Second Amendment rights. The NRA views the Second Amendment as a protection of reasonable firearms in reasonable situations for reasonable people. The NRA is a shit organization for defending the Second Amendment. It just happens to be, or have been classically, one of the biggest and most popular. But they know that if they go after fringe items, the NRA will often be silent on it. That's just, again, how they do it. Okay, do we want to check out the argument? Succeeding on the merits? No. I mean, they are under Bruin. That's the whole fucking thing. Final rule not authorized. And we got the main points here. NFS text precludes the final rule. And here we have a cite to Chevron deference. Hopefully the Supreme Court will review Chevron soon. Let's see. The final rule is unconstitutionally vague. Violates the First Amendment. Oh, this is interesting. Let's check this one out real quick. This is a short argument on this. As to the First Amendment challenge, the final rule does not merely allow the evidentiary use of speech as the agencies contend at 42, but is considering the speech of unknowable parties to determine whether particular brace pistols are short-barreled rifles. Nor is there consideration of third-party speech comparable to, quote, a defendant's confession, as the final rule allows anyone's speech about how a brace pistol might be fired to bear on the agency's determination of whether the NFA applies. As appellants explained, the final rule's content and speaker-based considerations will invariably chill protected speech, even though the final rule's goals could be furthered without a consideration of speech at all, as shown by speech's absence in the proposed rules worksheet 4999. Okay, so what they're saying here basically is that the agency will determine a speaker's description of how a brace can be used. They will use that description, an unknown speaker's hypothetical speech, to then make a determination that a brace violates the short-barreled rifle rule. Right? So if someone says, well, you could use, some unnamed person says, well, you could use it to shoulder fire a pistol or whatever, then suddenly it becomes a braced, or suddenly it becomes a rifle for the ATF. But that's silly. That would, as they're saying, chill how people speak legally about this subject, because they wouldn't want to potentially give the ATF a rulemaking quote from some random person. And also it effectively controls speech on the issue. So there you go. The First Amendment argument is very, very, like, this is one of those, you throw it in there. This is not a strong argument against it, but they did put it in there. It's kind of interesting. That's why I wanted to read it. Violates the APA substantive notice requirements. That's just with how rulemaking bodies make rules. There's supposed to be a period of time that goes by, and in a period of public review and public commentary. They're saying they violated it. I don't know. Doesn't really matter. That's not going to be the determinative issue. Appellants face irreparable harm. That was pretty obvious how they did that. Equitable factors that favor injunctive relief. Again, this is the equitable factors would be the likelihood of irreparable harm versus the public interest. How does the court balance equitably these two things? In this case, they're saying that obviously falls in favor of defendants, not in favor of the public. I agree. Injunction should be nationwide, not just for the coalition's members. I agree on that too. Kind of a weird thing that they did that. Okay, so there's most of it is covered in the introduction in a good enough way. We don't have to go through the whole document and all of the arguments in specificity. Obviously, they're briefed out. They have tons of citations. And if you want to dig into this, the Firearms Policy Coalition has it up on their website. It's really easy to find on there. It's Mock versus Garland. And it's all free. Anybody can access it. They've put it up on the website. And they have all of the briefing on there. I think I can show you. Yeah. So if you want to check it out, again, Firearms Policy Coalition has the whole thing from the district court starting on January 31st of 2023 through the ruling all the way up to the circuit court. This is the appellate court where they're arguing now. Again, up to June 20th, but starting on May 17th. You can check out all of the documents there and really get yourself into some good old firearms law, some Second Amendment arguments. Okay. Whew. All right. What do we have next? Oh, we have a Minnesota senator. We have a Minnesota senator to talk about. Minnesota senator. 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 Minnesota se This is good. This is fun stuff. We'll talk about this, and then we'll this won't take too terribly long, and then we'll shoot over to Rumble. Where the fuck? Here we go. So this is going to be on the topic of Roe versus Wade and the landmark Supreme Court ruling overturning Roe versus Wade, which happened, I think, in 2021. 2022? 2020. That was 2022. Cynthia J says, so no more trials. Who said no more trials? What are you talking about? Weird. Let's see. We've got Senator Tina Smith. This is a Minnesota, the U.S. Senator for Minnesota. And if you don't know anything about Minnesota, the overwhelming majority of our politicians are horrible. They're fucking horrible. They're terrible people. They need to go. They need to be voted out. But Minnesota has an addiction to terrible congressmen, terrible senators, terrible governors. They're really fucking bad at it. They just suck. The Republicans suck. Democrats suck. And they keep voting in people who will feign interest in some core values to go ahead and achieve power, and then use that power to oppress the state and its people. And I don't know why the Minnesotans are so addicted to it. You can really go ahead and blame the metro areas, and they're largely to blame, but the country ain't much better, honestly. Ain't much better. So let's take a look at this. This is from Senator Tina Smith. This is the level of discourse that we have happening from our Congress people. Republicans overturned Roe last summer. Wrong in the first fucking word, but okay. They spent decades influencing judicial nominations to put anti-choice judges on the Supreme Court. I mean, I guess. Let me get through this tweet before I address this. Now that they see how unpopular their stance on abortion is, they won't talk about the issue. So I will. Let's briefly discuss this. Roe versus Wade was never, ever good law. It was never a good ruling. And if you want evidence of how bad of a ruling it was, look no further than Ruth Bader Ginsburg, who supported abortion rights routinely, suggesting that Roe was a deficient and defective ruling. It's always been bad. It has been a federal government through the Supreme Court grab of power. It effectively wrote a more effective amendment guaranteeing a right than the first, second, third, fourth, fifth, sixth, seventh, eighth, ninth, and 10th Amendments. It's shocking how powerful Roe versus Wade was as a ruling. Any challenge fell always in favor of expanding abortion rights. All of them. It was more protected for a woman who was pregnant, who wanted to kill her baby, to do that than you to speak in a public park, in a courthouse, speaking to police. It was more protected than your freedom from search and seizure. It was more protected than your Second Amendment rights. It was more protected than quartering a soldier in your house. It was the most sacrosanct and sanctified freedom right that existed, and it's not even written down. And not only was it not written down, at the time of the passage of the 9th Amendment and the 14th Amendment and the 4th Amendment would not have even been contemplated in any of those contexts. In any of them. Yet, 9 white men in 1973 created a constitutional amendment that gave women abortion rights. And let's be very clear, that's what it was. It was the right to an abortion, not for a reason, not for conditions, not for anything. Now, you may think that women should have a right to abortion. Perfectly fine for you to have that position. I slightly disagree because I balance the rights of the unborn child and the interests of the state slightly above the interests of the woman in privacy in her abortion practices. Does that mean that I think that women need to be criminally prosecuted or anything like that? No, not really. But I do believe that having a third-party assisted abortion violates the rights of a child and is not something that should be protected by some sort of privacy interest of the mother. And I also think anyone making the privacy argument, which has been a big crutch of Roe versus Wade for a long time, a woman should have a right to privacy in her medical decisions, pretending that this is the right to that this right to privacy in medical decisions expands to anywhere other than abortion rights, because it really doesn't. And as evidence of that, you can look towards any number of government rules about your healthcare becoming public or at least non-private for any number of reasons. Vaccination requirements for public schools, vaccination requirements for government jobs. And I'm not talking about COVID. I'm talking about all of them. Drug tests for various issues. Plenty of people can infringe upon the privacy of your healthcare. But the only instance that was protected as if it were gospel were a woman's right, a woman who was pregnant's right to kill her unborn child. That's it. That's just a fact. It's a neutral fact on the issue. And that is something to consider when anyone makes the privacy in healthcare argument. You don't have privacy in healthcare. You're involving a third party. You're involving a doctor. You're involving a nurse staff. You're involving an administrative staff. You're involving an insurance company oftentimes. You're involving an insurance adjuster. You're involving a claims person. You're involving a receptionist. All of these people somehow get access to your healthcare, but you consider it private. And as a contrast, because I know some people will be like, well, we should be private even if we share with certain limited parties. You don't have privacy in banking. Whoever you write a check to, whoever you send money to, whoever you Venmo money to, Cash App, whatever you use to transfer money to another person, other than literally handing them a pile of cash, involves a third-party transferor who keeps the records of that transfer as part of regular business practice, and therefore the government does not need a warrant to look at it. It is considered not private info. Most people would consider their banking, their investments, their insurance policies to all be private information. They don't share them with their friends. It's not like you print out bank statements and post them online. Most of the time, people don't do that. Yet, the government has long ruled that the involvement of a third party annihilates completely your expectation of privacy, except here. Roe versus Wade, again, became the most protected constitutional amendment. It was not passed by Congress. It was not ratified by 2/3 of the states. It was just 9 white guys, 1973, deciding it. I only say the 9 white men because they argue that like white men want to stop abortion, all that stuff. Like it's just the meme of the fucking day. But that is who actually decided this. And they created the most powerfully protected right in United States history. It's crazy what it was. And it went well beyond the scope of what is constitutionally allowed. It went well beyond the scope of the federal government. And it violated, most importantly, one of the amendments, which says that powers not given to the federal government are reserved to the states or its people. Roe versus Wade the right to abortion, whatever it may be, has always been and belonged in the hands of the states. Republicans, take fucking note, you goddamn idiots. Lindsey Graham, talking to you. When the Supreme Court returned abortion to the states, it did it correctly. And then it's up to us as state citizens to advocate for abortion practices in our states that comply with the state's values and the values of the population. That's how it's supposed to be. That is the system that we established, and that system is good. The states should have more say on everything. I know we've fucking bastardized it because we decided that the Commerce Clause was bigger than anything ever. And when that fails, we use the tax and spend clause now after Obamacare to go ahead and just have a rubber stamp on everything else. But that's not how it's supposed to be. So, of course, when Roe versus Wade is overturned and it's finally back in the hands of the states, what do we get? But right before the 2020 election, Republicans trying to make a stupid fucking power grab and make it a national issue and issue a national ban. And the problem is, they didn't believe it. But that being said, it is now properly where it is because it was never properly part of the federal government's purview. And even worse, once the Supreme Court ruled on it, it took it out of even our Congress's hands. So the Supreme Court took it from a state issue, made it a federal issue, and made it constitutionally protected without an amendment. It took all of the power from Congress. The Supreme Court acted well outside their scope in Article 3. It's not the first time they've done it, but it's one of the biggest. All right, here we go. Next. So here, on par for the course, we will have an absolutely idiotic follow-up tweet from Senator Tina Smith on this issue. She will cherry pick not only the least likely occurrence to happen, two, one where likely the parties involved failed in some way to do something that would have prevented it, and three is probably a made-up story anyway, but we'll just ignore number three. Okay, here we go. Mylissa Farmer had already picked out a name for her child. Then her water broke 18 weeks into her pregnancy. There was no chance that her child would survive. Her doctors recommended terminating the pregnancy, but this was Missouri. Abortions were banned under state law. First of all, medically necessary abortions were not banned in Missouri under state law. So let's just throw that one out. Medically necessary abortions were not banned under state law. And doctors recommending the abortion and then saying they couldn't do it is fucking nonsense. Likely untrue. And then the next step of this is there's probably something that happened with the Farmer family where they failed to properly, and this not necessarily their fault, they failed to properly request what they were going for. They failed to go to the correct clinic. They failed to do it in a timely manner. Something like that prevented them from doing this is the most likely outcome if the story has any truth to it at all. Likely, it's untrue entirely. And make no mistake, let's enlarge for this. Untrue stories have littered the abortion argument since the initial one, which was that Roe was gang raped by a pack of black men, and that is why she got pregnant, which was not true, by the way. Roe's entire story was a fiction, a convenient Democrat fiction. Goes back a long time, y'all. But it was a fiction. And most of the stories about abortions and how abortions are enforced are fictions. And the reason that they're fictions is because they must make the laws, the doctors, the politicians, and the people opposed to abortion seem unreasonable. They must make monsters out of people because the alternative to them being monsters is people saying that babies' lives should be protected, which is a pretty easy position to take. So they must lie about what the unborn child actually is. They have to lie about fetal development. They have to lie about fetal pain. They have to lie about the traumatic results of abortions in women. They have to lie about the medical results of abortions in women. They have to lie about the increase in miscarriages that follow abortions for women. They have to lie about the trauma that happens to men in abortions. They have to lie about the impact that abortions have on protecting incest and rape and further victimizing incest and rape victims by protecting their perpetrators, by refusing to allow parents to be informed, specifically in cases of minors. They have to lie about all of these things because people opposed to abortion must be monsters. And I am sorry if this is the first time you're hearing it. And it never has had anything to do with the validity or the legality or the constitutionality of abortion, but it has always been part of the driving narrative around the conversation because you must villainize people who just go, I think babies should be born. Like, I think that's a baby that'll come out and not something else, and that it should be born. Because that's kind of a reasonable position. So you must make the unreasonable or the reasonable position unreasonable. And to do so, you typically need stories that support unreasonableness, which is why you'll always hear about the case of someone whose life was threatened if they didn't get an abortion, even though it happens statistically never. It's statistically never. Which means, if you don't know what statistically never means, the United States history of abortion is to the tune of over 60 million babies. Well over 60. I think we're pushing 65 to 70 million babies now. All right. The amount of medically necessary abortions to protect the life of the mother is somewhere less than 3 digits. In actuality, protecting the life of the mother, because overwhelmingly complications that threaten the mother's life happen late in the pregnancy, and the termination of the pregnancy is merely C-section delivery. Now, that does not mean the child will survive, but the necessity of killing the child in utero to protect the life of the mother is almost never. They tout it as the primary reason we need to protect abortion. And it's why Republicans generally are or should be okay with the idea of protecting medically necessary abortions. The problem with protecting them is the knowledge that so many people will lie about the necessity, and by people I mean doctors, will lie about the necessity of the abortion to actually perform an abortion that is not medically necessary. That's just reality, and it's a hard reality for people to swallow. Overwhelming majority of abortions are done for convenience, which, by the way, an honest discussion on this, convenience is a loaded word, but an honest discussion of this that recognizes the primary driving factor in abortion says, I'm fine with that. Which, if the right is what you're concerned about, if the right of the mother to have autonomy, bodily autonomy or whatever, you should be fine with the reality that something north of 97% of abortions are performed for convenience. Health of the mother, like not dying health of the mother, but just her general day-to-day feelings, the economic health of the mother is considered often in health of the mother as a reason for abortion. For example, the baby will cost money. That's true. Babies cost a shitload of money. No matter how much money you have, the answer to how much the baby costs is a shitload. So, but the economic health is actually, I believe, a WHO factor in women's health when they talk about health of the mother as a reason for aborting babies. Again, the entire discussion is premised on lies, exaggerations of the truth, false stories, because you have to make the reasonable position unreasonable. But if you're honest and you say it's about the right of the mother, then you have to say, then convenience is a perfectly acceptable reason. And it is, if it's about rights. And I will go ahead and couch that in how I approach the right to keep and bear arms. The Second Amendment right does not need a reason. Why do you need to own a gun? Because why? To defend yourself? Nope. To defend your family? Nope. To defend from tyranny? Nope. Because you're in a militia? Nope. Because you want to shoot it? Nope. Because your religion requires it? Nope. Because the Second Amendment exists and you want to support it? Nope. So why do you want to own a gun? Because fuck you. That's why. Same thing. If abortion is a protected right, the reason for the abortion is irrelevant. But they know that that's not a popular thing to say because it's not the principle of the right. It's the principle of the procedure for many, many abortion advocates. Typically ones in power. And I will say it. Many abortion advocates in power, I'm not talking about normal people who maybe have a passing understanding of the issue or just are passionate about women in general or women's rights or reproductive rights. Lots of those people are good-natured, well-intentioned people that I disagree with, and that is fine. But I will tell you that, in my opinion, people in power discussing the abortion issue, particularly from the pro-abortion side, but sometimes from the pro-life side as well, are legitimately evil, awful people who have aims beyond any professed protection of rights. These people do not care about rights. They have a demonstrated history of ignoring or usurping rights in every other context. So to suggest that they somehow care about individual liberty when it's only in this instance, I would humbly suggest that that is how they shield themselves from criticism over their true desires. Some people believe in depopulation. Some people merely believe in the destruction of the family or control of people's lives. Some people believe in keeping the Black population down through abortion, since it's predominantly Black children who are aborted. Some people have all sorts of reasons for this. That's my humble opinion. I find those reasons to be particularly evil, and I find their record on rights to undermine their professed protection of one. That being said, let's take a moment. Let's take a moment here to get a word from our sponsors, which is fieldofgreens.com. Fieldofgreens.com, promo code NOSE. Look, lots of Democrats want to abort your baby and take all those nutrients out of you. Fieldofgreens.com wants to put vegetables in you. And by vegetables, I don't mean Stephen Hawking. Someone probably pumped that penis up and put it inside of them. Gross, weird. These vegetables go in powdered form into a drink through your mouth and into your digestive system to bring you the health benefits of eating fruits and vegetables that you need without the inconvenience of having to have them around, have them go bad, having to prepare them, and all the other shit that goes. Look, Field of Greens is a convenient way to get one serving of fruit, one serving of vegetables in a tasty beverage, each one you take. I mean, you can drink one a day, two a day. It doesn't really matter. I mean, I guess theoretically there's a limit to how many you should drink a day, but I don't know what it is. It's got to be a lot. But Field of Greens will not abort your baby or your life. Field of Greens will just support a healthy diet and your overall well-being. And again, It's yummy. So you can have some and not feel sad about it. It's not like eating cauliflower. I kind of like cauliflower, but raw cauliflower is weird. Why does cauliflower? Never mind. Looks like brains. Fucking strange. Here we go. Field of Greens, very simple. You just add a scoop to like 16 ounces of water. This is what I do. I guess you could use less. And it's pretty good. I like the wild berry the best. The lemon lime took some time to grow on me, but now I like it. It's just good. Sometimes that's how your brain works too. You try things a couple times and then it's like, you know what? Actually not so bad. So here you go. You can also, if you're awesome, add some liquor to it. And just make it part of your daily consumption of liquor if you want. That being said, fieldofgreens.com, promo code knows. Big sponsors of the show. Big thanks to them for being supportive of the show and allowing me to make jokes like this one. Instead, why don't you put green Field of Greens dust in your beverage instead of Auschwitz dust, you evil Nazi? Like, we could say that it is more healthy to consume Field of Greens dust than burnt up bodies dust. I think that's okay. I might get banned for that one. I'm not sure. Anyways, look, there are a couple principles that I prefer in advertisers. A couple things I ask of them when they ask, will you advertise this product? I say, couple things. I got to try it. If it's garbage, I'm not going to advertise it. And you can't tell me what to say or not to say, period. So there you go. Field of Greens fits both of those. Let me hit the super chats on YouTube, and then we will move over to Rumble and keep going. We have a bit more on this abortion issue because I kind of got off on a tangent, and I want to wrap up that issue, and then we'll get the next topics are a little quicker on all of them. Some of them are kind of funny. Mostly Gluten says, I'm not pro-choice, but in terms of the Second Amendment, keep talking. I can only get so erect. Well, you need to get more erect then. Agrilith says, saw your local stream win the crowd Maximus. Big shout out to Legal Mindset hitting 100K. Yeah, that was awesome. That was you guys. Also, if some of you here are not subscribed on YouTube, at least, to my good friend Camelot 331, your boy was 100 subscribers from 220,000 subscribers on YouTube. Pretty cool milestone if he can hit it. If you're not subscribed to him, go check out his channel. Click that subscribe button and watch his content. Look, his live streams are great. They're very chilled out, laid back conversations with people. I'm on there quite a bit because I like to be, but he talks to a whole bunch of different people on a whole bunch of different subjects, and they're a lot of fun. Also, he does content that typically covers the actions of large corporate entities in America, or more appropriately, questionable actions of large corporate entities. And it's pretty interesting stuff. So go check out his channel on YouTube and show him some love, baby. Wolfgang Deo says late and works at Trans ET and not Target. Transit, and not Target. Okay, gotcha. He also says late due to needing more Bud Light from Transhauser. God, I cannot imagine drinking beer in general, and I can less imagine drinking light beer, and Bud Light would not be the light beer that I would choose either. Like Mario Kart 13, the Pikmin game that added a dog is the same game that added glow-in-the-dark Pikmin-based uncle that works at Nintendo. I don't know what the fuck that is at all. I don't understand what that means. I mean, I know of the game Pikmin. That's literally the extent of my knowledge of it. So I'm not sure what happened there. Tyrannomaster says, hey, Nick, stayed up late to sent you a Twitter DM yesterday. Same Twitter name. Feel free to read it on stream. I'll catch the video on demand. Oh, how long is it? That's what she said. Fuck. Is this? Hold on. Oh, here we go. Okay, here we go. Real quick. Hey, Nick, my wife and I don't stay up late enough to watch your show live anymore. Otherwise, I'd super chat. Well, he did. Last year, you recommended going to Pagosa Springs, and we just got back from our honeymoon there. It was great, and we were glad you recommended it. One of my favorite places on earth, Pagosa Springs, Colorado, specifically the Springs Resort. Amazing. We were also wondering if you were still planning on going to Anime Matsuri this year. Yes. And if you have a panel. I think so. Trying to get those answers from the owner as we speak. We didn't think we'd be able to make it, but family gave us some generous wedding gifts, so the trip is easily possible, but we might not go if the noseman himself isn't there. Thanks again for the honeymoon spot. Hey, you're welcome. You're welcome very much. And yes, I will be at Anime Matsuri this year. I believe officially as a guest. Again, trying to get that worked out. So there was a communication breakdown between the person who was originally organizing it with the owners. And now that's on me. And I'm trying to get those answers as fast as possible to make sure everybody gets there. But here's the deal. I'm going to be there anyway, because I have already planned my trip. So I kind of have to go. It's not like I can... I mean, I guess I could, in theory, ungo and skip it, but I've been telling people for a fucking year that I'm going, so I'm going to go. But as soon as I have that solidified, I will clarify that for everybody. And I want to clarify the full guest list, trying to get that set up and fully done. But I will be there. I believe Camelot will be there. I'm pretty sure Legal Vices will be there. I think Legal Mindset's going to be there. I think Nerdrotic may be there. I don't know who all else is going. Again, trying to work out all of that, and I'll get you the information as soon as I can. We'll figure that shit out. All right. If I skip it, you'll kick me in the nose. Again, my tickets are bought. My plane tickets are bought. I'm gonna be there. The question is, will I do panels like an official guest? Last I checked, I was, but I got to get confirmation from them. And I'm pushing on it, as often as possible without being too much of a fucking dick about it. Okay, Zim, the Despot, says, doing pretty good, Nick. Escaped the Hut's dungeon, poisoned those slimy slugs' homeworld, and decided to sit down and crack a cold one. Cool. Slaglust, you see Taylor Lorenz is getting sued. Ariana's defamation suit is moving forward. Okay, it's Ariadna Jacobs. I did not know Ari's suit was moving forward. I hoped it would be, but they got past the dismissal, I guess. I'll have to check into it. I'll check into it with her and see. And maybe she and I could talk about it, or Ron Coleman, our lawyer, could talk about it sometime soon. Great. Good. Fuck Taylor Lorenz. Piece of garbage. Jugi says, just wanted to say hi, buddy. Hi. Gliffy says, any chance of you getting Louis Rossman on and talking about right to repair state law that was passed versus the NIHS? Yes. Hopefully. I'm going to reach out to him soon. I've been meaning to reach out to him for a long time and have never gotten around to it. Now I have, again, this new sort of show format called Direct Examination. He'd be perfect for it. Pony Up says, Gavin Newsom announced his presidential run by announcing the proposal of a 28th Amendment that would ban all firearms in the U.S. Can amendments nullify one another? Yes, of course they can. The prohibition on liquor was an amendment that was unamended by the subsequent amendment. That's how we got the prohibition of alcohol and then the reinstatement of alcohol. Yes. The Constitution is infinitely malleable. They gave us a system to change the Constitution whenever the political will of the public was strong enough, which would mean you have 2/3 of the House and Senate, 35 or ratification, 2/3 of the states, 35 states right now. And then, of course, the president as well. Like that. I don't think you need a president, actually, but you need to have the collective political will to do so, to amend the Constitution. But it was a system that allowed it to be changed with the times. Now, the only reason we don't have a shitload more amendments is because in Marbury versus Madison, as I've discussed way too many times and also not enough, the Supreme Court took the unconstitutional power to decide an issue permanently or until a subsequent Supreme Court decision. They said, we know what the law is. That allowed for something called stare decisis, or binding precedent, as it's commonly referred to say that the Supreme Court could effectively make constitutional decisions. That's not in Article 3 of the Constitution, which establishes the Supreme Court. They do not have the power to do that, but they took it, and the other branches of government allowed them to take it. So here we are now, a couple hundred years in, with an unconstitutional Supreme Court acting unconstitutionally all the time, including with Roe versus Wade, importantly, making amendment-level decisions whenever they want. Not what it's supposed to be. We were supposed to have the political will to change these issues, which meant that the overwhelming majority of represented citizens, along with their individual states, would be going along with these political moves. But we don't have that. That's why we only have 27 amendments. Next. Pony Up also says, could you argue that the wording of the Second Amendment would disqualify it from being amended as a vector of infringement from the government? Nope. Amendment to the Constitution adds or subtracts from the Constitution in any way. It cannot be a permanently binding document in the way it's written. The process for amending the Constitution changes what's in the Constitution permanently. But it's so fucking difficult to do. That was the idea. The Gun Club says, Ricada Law, if you want to get into the tech side of braces, floating around the chat tonight. Happy to be of help if I can. Not today. Do want to do more focus like firearm stream. This one wasn't a specific firearm stream, so that's why no. Marcel DeFore, the commies always used to say America has the clocks, we have the time. It's the long game they want. Doing something over 30 years is easier than doing it in 1 year. God save the queen, man. Yep. That's how it's been. Cars in Depth says, if Chevron is dumb, would admin law be next? No, administrative law still would exist and be functional because Congress creates these entities to facilitate the enforcement of the law. Chevron deference would just not allow the agencies to create rules that have a legal effect outside of what Congress created. Congress's law would be the ultimate rule. Administrative enforcement of the law would just not allow expansion of it in theory. It would also allow challenges to administrative expansion to go forward more simply. Most of those challenges are dumped due to Chevron. Ginger Ninja, just as this rule was going into effect, that Nashville shooter used a brace firearm. Shocker. Yeah, isn't it weird how that happens? Remember the pistol brace thing or the bump stock thing right after that Vegas shooting? Very strange. Overnight Joe, note that Roe didn't claim gang rape to the Supreme Court, just to the Texas regulators who weren't allowing her abortion. Rape had zilch to do with the Supreme Court case. Right. The Supreme Court case had all sorts of other fucking problems. But again, gang rape, part of it, garners political support, becomes part of the story. It's a fun story. Drop Barracuda, best ad reads on the platform. Also, I thought there was a precedence going back to King Solomon and his 5th trimester abortions. Well, Solomon was the wise king. The wise king. All right, ladies and gentlemen, we are moving over to Rumble exclusively. I will see you over there. If you need a link to it, it is in the description of this show on YouTube. It is also in the pinned comment on the YouTube's live chat, so you can follow us over there. If you are not someone who follows onto Rumble, I will see you tomorrow night. Also, you can check me out after this show on my Locals exclusive live stream, where we kind of just have a more conversational sort of approach to the stream and have a lot of fun. I think tomorrow I will probably do a Locals call-in show following the stream, but not tonight. So we will see you guys over there. You thought the Bill of Rights were special and couldn't be touched? No, there's nothing special about the Bill of Rights. There just happened to be the first 10 amendments that were passed effectively alongside the Constitution itself. All right, guys. I will catch you next time or over on Rumble for the rest of the show. Peace. Peace.
For the thousands in attendance and the millions watching around the world, ladies and gentlemen,